permission. I am running with samples. Item 9, I have filed a memo for withdrawal of the petition with liberty to approach the appropriate forum. My friend is appearing for his end.
My lord, I am for the bank, but here is a case, my lord, where there was a suppression of material facts.
All right. The learned counsel for the petitioner has filed a withdrawal memo, which is a while. The Mr. Das submits that in view of such memo filed, may be permitted to withdraw the petition. Mr. Subrat Mishra and counsel appearing for the opposite party is present.
Lord, may I just raise subject to your lordship's consideration?
In view of the memo filed, the petition is disposed of as withdrawn. Yes, next.
My lord, may I pray, my lord? Because
you have no time to express.
Item number 5.
Yeah.
Because Mr. Speaker and myself both are running on viral fever. Somehow I managed to come.
You are mentioning
To seek for adjournment
whose behalf you are
on
mentioning.
25. Please vote it on 25.
On whose behalf you are mentioning?
On behalf of the petitioner.
Okay. Mention is made on behalf of Mrs. Rakhi Shikdar.
Mrs. Sajid, myself was Mr. Shikdar.
Your power is there.
Yes.
You are A. Shikdar.
Yes.
A. Shikdar and counsel for the 6 for an adjournment. Adjourn. Yes, next.
Let it come on 25.
No.
Pardon to mention.
Yes.
I have filed an interim application in jail criminal appeal. The appellant has been custody since 2011. So, madam,
Give.
madam, may come tomorrow, madam.
Please give it. Yes.
My lord.
It will come after Puja holiday. Yes, next.
Weekly list, item number 1.
In this case, the present petitioner challenging the impunity.
Has happened, have you filed the?
Yes, my lord, on last occasion, I have filed it on 12/8/2025. I have verified the court record through this. They have annexed the consolidated writ petition filed by me in the first, and the memo is filed in the earlier writ petition in the back, my lord. That I have seen.
Yes, yes. Consolidated petition filing is written. Okay. So, what is your prayer in this petition?
My lord, my prayer is, my lord, in this case, my prayer is specific to that impugned order annexure 1 and the impugned order at annexure 26, which is the review order. While I am placing the matter before my lord.
The review petition was dismissed on the ground of delay and laches.
Delay laches, my lord.
So, the order was passed
My lord.
on
16/11/2023.
My
lord.
Now, the review petition was filed on what date?
My lord, review petition is at annexure 25, my lord.
No, when it was filed?
My lord, it was filed on
16/11/2023 is the order passed in original application, right?
my lord, my lord.
Then when the review petition was filed?
My lord, review petition is filed, my lord, on
Because that order was passed on 27/2/2024,
my lord,
which you are challenging also.
my lord.
So we just want to know, have you stated anywhere
Yes,
that
my
what is
lord.
the date of the review petition?
My lord, in paragraph at page 387, my lord, of the writ petition, the cause is that.
Just a minute. Let us see that. 387.
My,
No, just want to know something. You are going here and there. We want that when the review petition was filed.
is 22.
1992 in the last page of a review petition,
My lord,
you see there is a print here. Is it the date? File number so and so, computer number so and so, generated from office of Ravi Prakash. Is it the date? You said there is no date.
question.
The Ganin tribunal has quoted
My,
the provision under section 17,
my,
that is rule 17 of the CAT procedure rules,
my,
in page number 449.
449.
Rule 17 of CAT procedure rules, and it says,
No, the list of date is keeps the date 19/1/2024. 19/1/2024 you filed the revision application.
Right.
Review.
19/1,
19/1/2024.
2024, and it should have been filed within 30 days from the date of receipt of the copy of the order
My lord,
sought to be reviewed.
my lord.
So have you stated what is your, when the review petition, what explanation you have offered?
My lord, that is at paragraph 5, my lord, of the impugned order that has been reflected, where the learned petitioner,
Please show us the specific paragraph,
my lord, 387, running page.
387.
My lord. The reason is that, my lord, in paragraph 5, in the meanwhile, in pursuance to Honorable High Courts of Delhi order dated 4/7/2017 in WPC number 11660 of 2015 Union of
No, no, we
India.
are not on merit. You see, once it goes there, then you want a review.
My lord,
The review was dismissed on the ground of delay,
delay, my lord.
and the provision is that you should file a review petition within a
30
period
days.
of 30 days
My
File
from the date
application,
of receipt of the order.
condonation of delay.
So
You
have you
filed.
filed that application for condonation of delay?
Yes, my lord,
So that is the main thing. You must keep in view that you should mention that though the 16/11/2023 order was passed, I received the order on such and such date.
my lord,
It should have been filed as per Rule 17 on this particular day,
my lord.
but due to this difficulty, it could not be filed. So where is that delay condonation application?
If you don't file an MA along with the review application,
Review application.
it is bound to be dismissed. You have not sought for condonation of delay.
My lord, what I know, the MA has been filed, but I have not annexed any
No, no.
decision.
Where is it? Do you have the application with you?
Initially, you did not challenge even the review order. That's why we give you opportunity to amend the writ petition, and you have filed the interim application. It has been amended. Now you are telling that one MA was filed for condonation of delay of the review petition. That is for the first time. That is not mentioned in the order of,
My lord,
or in the.
My lord, with regard to delay condon petition, I am not sure, but
You
the
told me just now-
review petition,
Because you see, in the impugned order, the MA number is not there.
my lord,
You see, please, that
My
order
lord.
come to annexure 26 is the
my lord,
review order, which is dated 27/2/2024. So if you would have filed the miscellaneous application,
my lord,
the number would have been at least reflected that
My lord.
miscellaneous application. So also the consequential RA stands dismissed. So that clearly shows that you have not filed any miscellaneous application.
my lord.
But if you say that in fact you have filed and the Central Administrative Tribunal has not considered that miscellaneous application, then you must not only produce that miscellaneous application, but also take some ground so that it can be taken into account.
There is nothing, no application was filed.
We are giving you
Well, let us
opportunity
see.
to get
Record-
proper instruction. Don't argue on on assumption that you might have filed. In pursuance of the order dated 15/9/2025, Mr. M.K. Patil and Senior Panel Counsel appearing for the Union of India has filed the consolidated writ petition. Stop. The Union of India, represented through Secretary, Ministry of Statistics and Program Implementation, New Delhi, and Director, National Sample Survey Office, Field Operation Division, Regional Office, Sambalpur, challenged the order dated 16/11/2023 passed by the London Central Administrative Tribunal, Cuttack Bench, in OA number 260/00095 of 2018, in which the opposite party, Sujit Kumar Behra, was the applicant, and the London Tribunal allowed the original application filed by the opposite party. Stop. When the matter was first taken up, on 13/2/2025, a submission was made by the London Council for the petitioners that against the aforesaid order dated 16/11/2023 passed by the London Central Administrative Tribunal, the petitioners filed a review petition before the London Tribunal, and the same was registered as RA number 260/0004 of 2024, and by the order dated 27/2/2024, the review petition has been dismissed on the ground of delay and latches. And accordingly, since the order passed in the review petition was not challenged in the writ petition, Land Council for the petitioner sought for some time to file an interim application for amendment of the writ petition, and accordingly the interim application was filed and it was allowed, and the consolidated writ petition was filed. On perusal of the order passed in the review petition dated 27/2/2024, it appears that since the original application was disposed of on 16/11/2023, but the review petition was filed on 19/1/2024, the London Tribunal, taking into account Rule 17 of the CAT Procedure Rules 1987, which states that no application for review shall be entertained unless it is filed within 30 days from the date of receipt of the copy of the order sought to be reviewed, dismissed the review petition on the ground of delay and laches. Stop. The London Council for the petitioner submitted that he has to obtain instruction as to whether any miscellaneous application was filed along with the review petition for condonation of delay. Since admittedly the review petition was filed beyond the period of 30 days, and he seeks for an adjournment, put up this matter on such and such. Yes, please.
Item 2.
In this case, we have not.
On 10/9/2025, we are also directed to the state, take instruction regarding this matter, will it challenge before the apex court or not? That is not challenged, madam. WBC number 34311/2023, passed by this honorable court. Similar matter was disposed of by the roughing message.
You made a specific submission on that day that it has
Madam,
been.
later on, I have taken instruction and
Not challenged.
no.
All right. On 10/9/2025, when the matter was taken out, Land Council for the Union of India on instruction made a submission before this court that order dated 10/1/2024 passed by the division bench of this court in WPC number 43110 of 2023 has been challenged before the Honorable Supreme Court. And accordingly, we adjourn the matter. And when the Land Counsel for the opposite party, Mr. Swain, refuted the contention raised by the Land Counsel for the Union of India, we adjourn the matter to enable the parties to apprise this court regarding the correct state of affairs regarding the challenge made before the Honorable Supreme Court to the order dated 10/11/2024.
10/1, my lord.
10/1/2024. to the top. Mr. Saubhagya Chandra Dev Das, Land Central Government Council, submitted that in fact he has obtained instruction that the order dated 10/1/2024, the aforesaid order dated 10/1/2024 has not been challenged before the Honorable Supreme Court. Yes, now you can have it. Yes.
So it's covered. It's
So
covered.
it is covered now.
You say that it is covered.
Yes, my lord, this is the covered matter.
So the
What are they?
Land Council
Okay.
for the petitioners fairly submitted that what is that order of the you are challenging? Which order?
And it's 27 hour.
My lord, on order annexure 5, dated 27/4/2023, passed by the London Central Administrative Tribunal.
Ajay,
Court of Appeal.
fairly submits that the impugned order passed by the London Central Administrative Tribunal dated 27/4/2023 in OA number 407 of 2017 was based on the inter alia, where based on the order dated 10/1/2024 passed by the division bench of this court in WPC number 43110 of 2023. Stop. The he further submits that the ratio laid down in the aforesaid case, so also in the case of State of Punjab and others versus Rafiq Masia Whitewasher and others reported in 2015 for SCC 334 also covers the issue raised by the opposite party for seeking a relief before the London Central Administrative Tribunal. In view of such submission, we are of the view that the London Central Administrative Tribunal is justified in holding that the recovery of 49,560 from the retirement dues of the opposite party towards the differential amount drawn due to erroneous fixation of second MSCP long back is not sustainable, and therefore was the order dated 14/3/2007, and the London Tribunal is also justified in directing the petitioner to refund such amount to the opposite party. We find no infirmity or illegality in the impugned order passed by the London Central Administrative Tribunal. Accordingly, the writ petition being devoid of merit stands dismissed.
Item 3.
Item 3 million. On behalf of Mr. Mohanty, he done personal liability. They are elected day after tomorrow, million. 3 and 4 adjournment. The state has filed the challenge the order of the state.
Let it go after Puja holiday. A mention is made on behalf of Mr. Aurobindo Mohanty and an additional standing counsel who was supposed to argue the matter on behalf of the state of Orissa, that he has some personal difficulty and the matter may be taken up on some other day. List this matter after ensuing Puja holidays.
3 and 4.
3 and 4.
Same after Puja holidays, item number 4 also.
So for 3 concerned, they have filed the amendment petition.
What is that?
So for 3, item 3 concerned, that is
So let it be taken up together. Hence you are seeking adjournment, we cannot take partly and then it is all to be taken up after Puja holidays, these two matters. Okay, yes, next.
Item 6.
In item 6, I am for the petitioner my lord through VC. My limited question here is, I am the owner of a cold storage consisting of about 52,000.
No, that is 5. This is 6 item number 6. Yes, Mr. Acharya.
Yes, ma'am. My limited point here is I was the owner of a cold storage consisting of about 52,000 square feet or 55,000 square feet, out of which I entered into a sale deed in the year 2007 with this private opposite party, and I sold only 4,000 square feet of the entire cold storage, which is quite evident from page number 34, my lord, of my writ petition. Now what has happened after the sale deed was executed, now this person took a loan from HDFC Bank and he mortgaged the entire building of mine, my lord, not only this 4, because he was entitled only for 4,000 square feet, but he has mortgaged the entire 55,000 square feet. And the mortgage was created.
Mr. Acharya, recovery officer's order, how can you challenge in a writ petition?
Yes, my lord, I'm coming to that. There is a judgment of our own High Court. I'll just, 1 second, my lord. This is a judgment passed by Honorable Justice Dr. B.S. Chauhan and Justice Indrajit Mohanty, 2009, Volume 2, OLR, page 374. There they have said, if the recovery officer is working not on the administrative side, but on the judicial side, so any orders passed by the learned recovery officer is a quasi-judicial order, my lord.
Thereafter, Mr. Acharya, thereafter so many decisions have come. As you know that when the alternative forum is available in the form of ERAT, so even it is strictly stated that
challenge it in DRT itself. You can challenge it in DRT itself.
There is a provision under section 30 to file an appeal before the presiding officer, my lord. But
Against
I was just
recovery officer's order, you can challenge it in DRT itself.
under section 30, there is an appeal provision. But I was just relying upon this particular judgment of our own High Court, my lord. Because this judgment clearly says that because it is a quasi-judicial order, I mean, this court has the power to hear it under 227. I'll just read out that particular paragraph, my lord, for a moment.
You are appealing for whom?
The associate of.
He is my associate. I'll just
Judgment.
You're talking about some judgment.
Your senior is citing some doubt so that you should give it to us. How can we peruse it?
Where is the judgment, Mr. Acharya?
Can it be passed over? Can it be passed over? I'll just send it across, my lord.
No, we are taking upon some other day. Just please give the judgment so that we can see.
I'll do that.
See that if there is any contrary decision of the Supreme Court because some other matter it was placed that there are those view has now been given a go by, so that up to date
I'll look into it.
When the matter was taken up and Mr. Acharya and senior advocate placed the impugn order dated 30/8/2025 of the recovery officer, which is annexed to the writ petition as Annexure 1. we posed a pertinent question to him as to how this writ petition is maintainable. Mr. Acharya submitted that in view of the ratio let down by this division bench of this court in the case of, yes, Mr. Acharya,
Gobind Chandra Patnaik,
Gobind Chandra Patnaik versus
presiding officer DRT Cuttack,
presiding officer DRT Cuttack, reported in
2009, volume 2, OL
2009,
9, volume 2,
volume 2,
OL 374.
Orissa Law Reviews.
Yes, my lord.
Orissa Law Reviews, page
374.
374.
Yes, ma'am.
374. Please check it. 374 states that such order can be challenged before this court in the writ application. However, since some contrary decisions are available, Mr. Acharya submits that he will verify all those decisions and will place it on the next date, keeping place this matter on such and such date. Yes.
Oh, bless, ma'am.
Item 7.
Wait, please. Not here. It pertains to you are filing an application for exemption of filing certified copy. Why?
Because, my lord, it was disposed of on Guruvar disposed of ହେଲା ତ ସେଥିପାଇଁ ପାଇନଥିଲୁ କପିରେ ସେଥିପାଇଁ
କଣ ହେଇଛି?
disposed of ହେଲା ଗୁରୁବାର ନା ଆମକୁ ମିଳିଲା ଅର୍ଡର ବାହାରିଲା ତ ସେଥିପାଇଁ ଫ୍ରାଇଡେ ଫାଇଲ କରିଲା ବେଳକୁ ଟିକେ ପ୍ରୋବ୍ଲେମ ହେଇଥିଲା।
Now certified copy is available with you.
ନା ଆସିନି।
You have already applied.
Yes, my lord.
You take up day after tomorrow. What is the
problem is that the interview is going on, and my lord, that is the problem, my lord. Under the notification, my lord, they have to follow a scheme for the ST and SC.
No, unless the order
is there, my lord. Order is issued.
Once you file a Xerox copy, how can we rely upon it? That is the main thing. And you have applied for the certified copy. We can take up day after tomorrow. But Mr. Patnaik, Land Council, appearing for the petitioner, though has filed an interim application for exemption of filing the certified copy, however, is submitted. The certified copy has been applied for, and the matter may be taken up day after tomorrow in view of the urgency, so that he will avail the certified copy and file the same. Put up this matter on 24th of September 2020.
Another thing is that we need to make Central Administrative Tribunal as a party, man.
Why?
It's required under. That is my instruction. I'll verify with the guys.
Why should you make
Central and what is
central
it?
administrative?
Order has been passed, you can share the order. Why Central and
Nowadays, it is not necessary, madam. Nowadays, it is not necessary. Initially, Justice Goyal had given a judgment, thereafter, again, Supreme Court let down. So, there is no need to implement the party as a central government.
Why? Tomorrow you will challenge the order of this court and you will make the High Court a party. Yes, next.
Item 8.
May please your lordships.
Yeah.
Lordships, this contempt petition is filed.
Which order has been flouted according to you?
Lordships, Annexure 1.
12/5/2025.
Yes, your lordships.
Order to the operative portion at page number 17.
Yes, your lordships.
Please read it out.
Accordingly, we dispose of the writ petition with observation that after removal of the standing crops, immediate steps shall be taken for field verification and a detailed demarcation by the authority concerned, with prior written notice to the petitioner to remain present at the time, and a copy of the report in that respect shall also be provided to each of the petitioners. After preparation of the report, if the authority find that any land of the petitioner, as has been mentioned in paragraph 8, has been utilized for construction of river embankment, etc., for which no compensation has been paid, steps shall be taken in that respect. After receiving the report, the petitioner are also at liberty to take appropriate step in accordance with law.
So what happened now?
Your Lordship, the order is duly communicated on 2nd June 2025.
No,
With
but the conditions are there that standing crops are already there. So that cannot be field verification cannot be made, detailed demarcation cannot be made. So whether that standing crops have been removed in the meantime.
Yes, Your Lordship. The
What is your
crops,
argument? Let us see.
Lordship, the communication is in para 4.
Communication memo, communication kale kono. Tapre condition thila na. Where have you stated that standing crops have been removed? So there is no hurdle now for making the field verification or demarcation. Where have you stated?
Yes, Your Lordship. At para 4, actually, Your Lordship, the order.
Let us see that. What have you stated?
Lordships, it was before the, it was in 2nd June 24, before the next crop season. The
Para 3, you have said that. Why are you not reading last paragraph? Therefore, the harvesting of the previous crop are completed well before. And in the reasonable circumstances, standing crop of so and so, so and so.
Take instruction. This contempt petition has been filed by the petitioners for deliberate and willful disobedience of the order of this court dated 12/5/2025 passed in WPC number 9988 of 2025. In the operative portion of the order, we hold as follows. Quote that portion. The land counsel for the petitioner, in the content petition, it is averred that the harvesting of the previous crops were completed and there is no reasonable circumstances, standing crop or active cultivation as on 28/4/2025. And the order passed by this court was also duly communicated to the opposite party contemners. And in that respect, he has annexed the letter sent to the opposite party number 2 na eta collector को issue ହେଇଥିଲା ନା ସମସ୍ତଙ୍କୁ issue କରିଥିଲେ
Lordships 2 and 3, collector and tahsildar.
2 and 3. Stop. Let the land council for the state at this juncture seek some time to obtain instruction regarding compliance of the order dated 12/5/2025. Aforesaid order dated 12/5/2025. Put up this matter. Put a date
A few days back, you had another matter, similar matter.
On 13th of October. The other matter is listed on 13th of October. October.
13th of October. 13th of October 2025. Same order, similar order was passed.
Yes, Sir Lordship.
Can you tell us that what is that other content number?
It is 3910 of 2025, Lordship.
Stop. Mr. Beura, Land Council, appearing for the petitioner, submits that since similar content petition is also pending before this court and it is adjourned to 13/10/2025, that is content petition number
3910 of
2025. This matter may also be listed on that day. List this matter on some week. Yes, next.
Obliged, Your Lordship.
Item 10.
You have not filed the postal cover and postal fees. You are in this petition. Item number 10. Mr. Pari.
not file any requisition.
You are appearing for Union of India.
For the OP manner. Filing the OP.
You have already entered appearance.
No, to the appealing manner.
Fine. Sole opposite party.
Yes, ma'am.
Have you received the copy of the
No.
writ petition? Oh, what is the? Mr. Nayak, tell somebody to Union of India.
There is a stay in my content.
That's just a
pending report.
What child is health call? I don't know.
My colleague.
Lekon, Mr. Chandi Prasad Sahani and his associates have already entered appearance for the opposite party and files wakalatnama which is accepted. The name of the land council for the opposite party shall be reflected in the cause list henceforth. The office has pointed out that due to non-filing of the postal cover and postal fees, notice could not be issued. Since opposite party has already entered appearance, there is no requirement of filing the postal cover or postal fees. So, the land council for the opposite party, however, submits that he has not received the copy of the writ petition. Let a copy of the writ petition be served on the land council for the opposite parties by day after tomorrow. Matter be placed immediately after the reopening of the court ensuing puja holidays. Yes.
Item 11.
Yeah.
Have you filed bail application?
No, my lord, in course of the day, I will file in course of the day.
Rule on that day. How much time it will take to file a bail application?
Contact ହେଇ ପାରିଲାନି ତ phone number
କାହାକୁ contact କରିବେ ଆପଣ?
ତାଙ୍କର family member କି phone କରି
କିଛି ଦରକାର ନାହିଁ। ଆପଣ ରେକର୍ଡ ଅଛି ଆପଣ ଏଠି ରେକର୍ଡ ଅଛି ଦେଖଉଛି କେବେଠୁ ସିଏ କଷ୍ଟଡିରେ ଅଛି
14 ବର୍ଷ 3 ମାସ
he is in custody for 11/6/2011 the custody certificate is here ତାଙ୍କୁ କଣ contact କରିବେ କଣ ଦରକାର ଅଛି ଆପଣ you have to file an application that he is in custody since
normal one page application
2 page applications
ready करके ଆଜି ହିଁ file କରିବି
file it the land council for the it will be listed tomorrow you file it and give a copy to him so that it will be listed
who application day of realization file
whatever you are the land council for the state has filed the custody certificate which shows that the petitioner the appellant is in judicial custody for more than 14 years the custody certificate is taken on record. You are Miss Manashwini Raut. Miss Manashwini Raut, land council appearing for the appellant, submits that during course of the day, he will file 2 interim applications, one for bail of the appellant and the other for stay of realization of fines. List this matter on 24th of September 2025 with the interim applications, if any, filed by the land council for the appellant. Yes.
Item 12.
No. Witness custody last 12.5 years.
At 13 years, 5 months. 13 years, 5 months.
13 years, 5 months.
02 case.
Okay.
The killed baby child, that's all.
Majority the
That's
case was
what
entered
about-
under 307.
Very challenging.
Are the land council? Are the land council for the petition, land council for the state? The land council for the petitioner submitted that the petitioner is in judicial custody for more than 13 years. And there is no chance of early hearing of the appeal in the near future, therefore the bail application may be favorably considered. Land council for the state has probably the custody certificate of the petitioner which shows that dated for them, dated 21/9/2025, which shows that the petitioner is in judicial custody for more than 13 years and 5 months. The custody certificate is taken on record, considering the submission made by the land council for the respective party, period of detention of the petitioner in judicial custody, absence of any chance of early hearing, we are inclined to release the petitioner on bail, stay relation of harm.
Item 13.
While IA for against for bail. Collected in custody since 29/7/2011. 14 years.
Two.
Who is the IO?
It is the mother, verified my lord.
Who is the eyewitness? The छुआटा को पछाड़ी की मारती.
Lifted the child and 3 organ given.
PW7 is the doctor. That's what.
Method arising out of a sudden provocation. He quarreled with his wife and was intent to assault his wife. He threw his 1-year son.
Let them do it. The IN number 277 of 2025, an application for bail. Mr. S.K. Japrulal and counsel appearing for the appellant submit that the appellant is in judicial custody for more than 14 years. And there is no chance of early hearing of the appeal in the near future. Therefore, the bail application may be favorably considered. And counsel for the state has produced the custody certificate dated 21/9/2025 from Superintendent District Jail Bhavani Patna, which also shows that the custody period of the petitioner is more than 14 years. Custody certificate is taken on record, considering the submission made by the land council for the respective parties. The period of detention of the petitioner in judicial custody and absence of any chance of early hearings, we are inclined to release the petitioner on bail, stay relation of harm.
Order be communicated.
Order would have communicated and we called the Sahoo Hon'Ble. So order would have communicated our jail criminal appeals. So the jail superintendent to go. I would district jail to the Yes.
Item 14.
It's not filed the IA for bail and relation of final.
I have not got the passport.
Mm-hmm. 14. Item now 14.
14 method is the custody
14
years 1 month. 14 वर्ष.
Custody
And moreover,
2011.
Since 8/10/2024, we now is under treatment in the SC medical.
IA number also there is an application for bail. The land council for the petitioner submit that the petitioner is in judicial custody for more than 14 years. 14 years. And there is no chance of so until of advertised later. Land council for the state has produced the custody certificate, which also substantiates the submission made by the land council for the petitioner. The land council for the state further submits that he has received the instruction that the petition.
The instruction is written in the last.
Pudi.
Custody certificate last. The convict was admitted SC medical college.
That the petitioner has been is admitted in SC Medical College Hospitals in 8/10/2025, and he is undergoing treatment at destitute ward of surgery department. The the custody certificate along with the written instruction is taken on the form. Considering the submission, period of detention of the petitioner in judicial custody and absence of any chance of early hearing, we are inclined to release the petitioner on bail, stay relation of time. Yes, next. Yes, next.
Item 15.
Item 15, my lord, I have obtained the custody certificate as well as criminal incident.
My lord, in item 14, we will come some. Yes, yes. Yes,
Custody certificate and criminal incident.
but where is that IA? Here.
More than 6 months in custody.
Understand. Please show the custody certificate.
13 years, 5 months. No, no, the detail, what a criminal and
302.
Yes, my lord, 302. All the criminal
Brother,
accident,
he has killed his brother.
yes.
Acha, handle of the arts, okay.
Custody certificate and criminal accident. No criminal accident.
IA number 287 of 2025 with an application for bail. Grant counsel for the petitioner submit that the petitioner is in judicial custody for more than
13 years, 5 months.
13 years. And the petitioner is having no criminal antecedent. Therefore, the bail application may be favorably considered. Land counsel for the state has produced the custody certificate, which also substantiate the submission made by the land counsel for the petitioner. And it has also been, the certificate has been obtained from the Superintendent District Jail Keonjhar that the conduct of the appellant inside jail is satisfactory. Land counsel for the state has also produced written instruction received from IIC Bamaberi Police Station, Keonjhar, dated 29/2025, that nothing adverse was found against him, against the appellant. The reports and the custody certificate are taken on record, considering the submission made by the land counsel for the respective parties, period of detention of the petitioner in judicial custody, absence of any criminal antecedent, and absence of any chance of early hearing of the criminal appeal in the jail criminal appeal in the near future, we are inclined to release the petitioner on bail now.
Maybe coming.
Out of communication, yes.
Item 16.
I filed a bail application on another. I have also wrongly filed the bail application.
Custody certificate.
My lord, I have funded the custody certificate, jail conduct and criminal accident.
What size?
More than 12 years.
13 years, 6 months, total days.
13 years,
My lord.
including that remission.
Yes, my lord.
Remission is 1 year. Acha.
1 year.
And no antecedent.
No accident, jail conduct is also good.
Lekhontu. IA number 218. So there are two interim applications.
Wrongly another application.
Acha,
Filed another.
what is your application? IA?
281.
281.
81.
IA number 283 of 2025, the land counsel for the appellant does not want to press this application, disposed of. IA number 281 of 2025, the land counsel for the appellant submits that the appellant is in judicial custody for more than 13 years and is having no criminal antecedent, and there is no chance of early hearing of the appeal in the near future, and therefore the bail application may be favorably considered. Land counsel for the state has produced the custody certificate, which also substantiates the submission made by the land counsel for the petitioner. He has also produced the report from IIC Hemgir Police Station dated 29/2025 to show that there is no criminal antecedent against the petitioner. Considering the submission, the period of detention of the petitioner in judicial custody, absence of any criminal antecedent, absence of any chance of early hearing, we are inclined to release the petitioner on bail. Allowed. Next. Can come order be communicated. Yes.
Item 17.
And there is a typo error in case number and also the name of the appeal. Bail has been granted? Yes.
Interim bail was granted for.
Who order a typographical error is 59 2025. 59 ne? Yes. The na kon ki Sona Munda thik to? And second line ne Arati Vanchu. Oh, Honadi Vanchu. All right. The case number कौन भूल लिखा है इसको? केस नंबर टा भी ऊपर 2021 जगह 11 साहू होम केटा देखियो होला मोटा प्लेस करियो. The registry has pointed out that there are typographical errors in the order dated 15/9/2025. Order number 5, order number 5 dated 15/9/2025, which was passed in IN number 223 of 2025. In the second paragraph of the said order, the name of the appellant has been wrongly mentioned as Onadi Panchor in place of Sona Munda. And the jail criminal appeal number has also been wrongly mentioned as JCRLA number 27 of 2011 in place of JCRLA number 27 of 2021. Stop. In view of such typographical errors, we modify the said order and direct that in the second paragraph of the order dated 15/9/2025, order number 5 dated 15/9/2025, passed in IN number 223 of 2025, in place of Onadi Banchor, the same shall be read as Sona Munda, and the jail criminal appeal number shall be read as 27 of 2021 in place of 27 of 2011. The rest part of the order shall remain unaltered. Free copy of the certified copy of the order. A free copy of the order be handed over to the Land Council for the state. So also urgent certified copy. Yes, next order.
Item 18.
My lord, both are the appellant are both are husband or wife. They are both
Case
are
under
husband.
Yes. The case under question, they have given the wakalatnama for engagement of a legal aid counsel.
Acha. The reason, sir, पठेई देबे ठीक है High Court Legal Services. हाँ? आओ कौन? क्यों? Solving है लापर से पठेई दी थी वकालतनामा एंगेज करियो से और कौन? देखो IN number 177 of 2025. The Land Council for the state submitted that not only notice has been served on the victim, but also she has sent the signed wakalatnama for engagement of the council from the High Court Legal Aid Committee. Stop. The wakalatnama issued by the Land Council for the state is taken on record. The same shall be sent to the Secretary, High Court Legal Aid Committee for engagement of a counsel for the victim, and the prisoner's petition judgment copy, and the interim application for bail shall be handed over to the learned counsel for the victim. है ना? Put up this matter after ensuing puja holiday.
Item 19.
Item 19 also they have sent a wakalat, it is yet to reach us.
Recently.
पहुंचने में recorder पहुंचने
And फर्क ना होगा ही.
पहुंच recorder पहुंचने.
अच्छा. But you have instruction that.
Yes.
Can it be produced today? We'll write or it will be.
They sent it yesterday evening to
Achha.
take it.
All right. The learned counsel for the state submits that as per the order 629 19/2025, he has received instruction that the informant has sent informant he's now
IIC पठोचंदे
नहीं informant फोन है जी informant has sent signed wakalatnama through IIC Chowdhury police station for engagement of a counsel from High Court Legal Services Committee, and the matter may be taken up on some other day as she is yet to receive the wakalatnama. So এটা আসিব না 14 থানারও আসিব তো
আজি
it can be taken up day after tomorrow.
Day after.
Put up this matter on 24th of September 2025, and counsel for the state shall produce the signed wakalatnama of the informant, right? All right. Yes.
Item 20.
May I please ask a minute? In custody since 2015, madam.
Report is come.
No report was called for in this matter.
Case is based wholly upon the
Waiting. Both of you have received the deposition copies of the witnesses. What is the period of deposition?
Man, I am custody since 2/3/2015. 1/3/2015.
15.
Yes.
That is also reflected here from the final form 1/3/2015, and you are never released on bail during trial. Accused produced in custody, produced in custody, produced in custody. What is the prosecution case?
The prosecution is for informant matter. Well, while the deceased was sleeping in her veranda, his veranda.
Come to paragraph number 2. Two of the infant judgment.
Yes. That the case of the prosecution in brief is that the alleged occurrence took place on 24/2/2015 about 10 p.m. on the fateful date and time when the deceased Somnath Guntha, the husband of the informant, was asleep on the veranda of his house. The accused Madhava dragged him towards his house and stabbed on his chest by means of a spear, for which the deceased succumbed to his injuries. Their co-villager, namely Sri Narsinghdara, intervened the matter and snatched away the spear. Immediately, the deceased was shifted to Asakiran Hospital, but on the way, deceased died. Having been aggrieved, the informant Subarna Khila, being the wife of the deceased Somnath Guntha, report the matter before the in-charge officer, Namtaput Beat House, who entered the facts in Beat House station diary bearing number Namtaput Beat House SG number 249 and sent the.
Eyewitness, sir, there. Eyewitness.
Yes,
PW
they are
one-
saying eyewitness, but the.
Yes, eyewitness, sir.
PW 1, 2, and 6, I'll be placing PW number 6.
PW
1, 2, and 6.
1, 2, and 6.
6.
With the doctor, PM doctor.
Doctor has
Doctor has not
not
been examined, ma'am.
What is the exhibit? PM report.
Yes, yes. The exhibit is,
Exhibit 9.
9.
yes, yes, exhibit, madam.
Exhibit P12.
Huh?
P12.
P12 also. PM report. I don't know. Report.
Single blow, vodka.
Yes, madam.
Placing PW 6 with the one of the eyewitness.
Reverend trial court to hold the rely on PW 6, ma'am.
May I please? Paragraph 2 of the PW.
Why he 1 and 2 have been disbelieved or what?
No, 1 and 2, Fellowship, in the cross-examination, they have stated that somewhat they reached after the occurrence.
Acha, so 1 and 2 have been held to be post-occurrence witnesses.
They have not been held, but PW 6 is more vital than.
Acha, PW 6 has been relied upon.
Yep.
Let us see the PW 6 evidence.
Yes.
Para 2 years. So stop.
Just a moment.
May I please see?
Yes, please.
Paragraph 2 of the PW 6.
hold on.
The occurrence took place near
PW
the
6 कौन था ना उसी नौरव सिंह
Nothing, Dora.
Dora.
The informant saying ki.
The occurrence took place near the house of one Ramachandra Dora. By then, at about 9:30 p.m., I had been to the house of Samma to watch the TV. And while returning the house after watching TV to my house, I heard the noise Morigali, and having heard this, I focused my torch towards him. And I noticed that the accused Madhava Dora was assaulting by means of a spear to Somanath Gunta on his chest and also pressed his neck. Subsequently, thereafter the poster. Since thereafter the cross-examination, paragraph 3, last 5 lines from the bottom, Your Lordship.
Which paragraph?
This
Three.
is the 3, Your Lordship.
Yeah.
In his cross-examination, he states, the house of Samma is situated between my house and the house of deceased. The house of deceased is situated in Upper Sai, and thereafter the house of the Shamma, where I was watching TV. And thereafter my house is situated, and the house of the accused Madhava was situated after my house is electrified. And after watching TV, first I came to house, and while standing in the house, I heard screaming of the deceased. The house of the Somanath Gunta is situated about 70 meters away from the house. When I reached the spot, I found us accused pressing his neck of the deceased by sitting on his deceased.
So what about the criminal antecedent?
No, ma'am.
I don't have the reports.
Yes, it is stated in the.
What is it?
227, ma'am.
Where in which act?
227, the PCR.
2?
LCR page 227.
Nothing is there.
No CM error. It's
That is not there.
227 page.
कोणाला पाहिले? Food पाहिले 227. There is nothing.
Test बोले था, but I
Get it. The land council for the state, जो main god, High Court rate account.
ମୁଁ ଯୋଉ ଏଲସିଆ ଟା ନେଇଥିଲି ସେଇଥିରେ ଅଛି
କାହିଁରେ
ମତେ ଯୋଉଟା ଟିସା ଦେଇ ସେଇଥିରେ ଅଛି ଇନ୍ ଦ ପେନ୍ ଟାଇପ
ନାହିଁ ତ ଦେଖିଲେ
କୋଉଠି ଆପଣ ଦେଖୁନାହାନ୍ତି କୋଉଠି ଅଛି କୋଉ ପେଜ ଅଛି କୋଉ ଡକୁମେଣ୍ଟ ଆଣିବ
I took the teaser in my pen drive. It is not 227.
What is that document?
That is CD, my God.
ନାହିଁ ତ ଆଉ ଦେଖିଲେ ଆଉ କଣ the IA number 254 of 2025. The Land and Council for the state submits that as for the order dated 15/9/2025, she has received the deposition copies.
It is at page 223. A part of this says verified the criminal incident, the accused one.
We have to supply the deposition copies of the witnesses in our pen drive. Yes, 220.
3 years.
I declare. 223. Verified the CA is available and found nothing. Acha. The Land Council thing. The Land Council for the petitioner submits that the petition is in judicial proceedings 1/3/2015 and he is having no criminal antecedent. And since there is no chance of early hearing of the appeal, in the near future, the bail application may be favorably considered. Land Council for the state, on the other hand, placed the evidence of EW 6 Narasingha Dora, who is an eyewitness to the occurrence, and also the postmortem report, which has been marked as Exhibit P/12, and submits that the medical evidence corroborates the version of the eyewitness, PW6. Considering the submission made by the Land Council for the perusal of the case diary also shows that the petitioner has got no criminal antecedent. Considering the submission made by the Land Council for the respective parties and available evidence on record, while not inclining to release the petitioner on bail on merit, but taking into account the period of detention in judicial custody, absence of any criminal antecedent, and absence of any chance of early hearing, we are inclined to release the petitioner on interim bail for a period of 3 months. While on interim bail, the petitioner shall not indulge in any criminal activity and shall not come in contact with the family members of the deceased. Violation of any terms and conditions shall entail cancellation and bail, matter to be placed 3 months after. What is the surrender certificate? Yes, next.
The state relational file. I have filed IA for not firm. I will give the number.
What is that IA?
Not firm.
No, you have to tell the number or no, not firm.
Number type they do.
Number the
Yes.
যদি সে IA number দিতে state relation of fine তাহলে allow করবে। Yeah.
Item 21.
20 I prefer after vacation since it's triple murder.
20 the wala
21.
21 अच्छा Land Council for the appellant 6 for an adjournment after puja holidays. Yes,
The paper book.
paper book पाई ना थी?
No.
अच्छा, let a copy of the paper book be served on the Land Council for the appellant. अपन पाई जाती?
Yes.
Yes.
Obliged.
Item 22.
Sorry, man. That order may be permanent to the jail.
So does
I don't count. Yes. Obliged.
Date of the appellant, अच्छा. Sole appellant. Yes.
Yes.
Review the report of the officer in charge, Jujumara Police Station, which indicates that the appellant, Yakira Barjo, has expired since 29/11/2018. Hello? No application has been filed by any of the near relatives to continue the appeal for provision dispose of further. Yes, next.
Item 23.
Petition is being prospered since 27/6/2011. And the authoritative portion of the judgment has been convicted for offense under section 302 and 449 of IPC. 302 for life and
Just a minute. And he doesn't page, na? But should you execute it and final from the one? Judgmental children. Wait. Final form में कहीं नहीं आते देख लो जो legal document final form में नहीं custody के लिए कोई अपना आणखी दी custody certificate item number 23
No, it's not called to.
नहीं आज ये final form पे से particular page टा नहीं माने first page अच्छी second page अच्छी
Solve this matter day after tomorrow, I'll get the.
हाँ नहीं just देखियो हम गोटे कहयो ना एंती हम खेरी घर पकड़ुछन original report आसुनी तो माने जेरो स्कैनिंग report
Yesterday was arrested on 27/6/2011.
27
6/2011. Page 371.
ठीक है you are right 27/6/2011 Vidura Baran apprehended and brought to the police station and he was also examined and same day he was forwarded. So 27/6/11 money
Custody.
bail ले जाएंगे
no
accused produced in custody. हाँ तो हेला अपन करो 27/6 माने अपन को हेला 14
Around 13
14 वर्ष मर्डर कितना मर्डर
single.
one
Based on circumstantial evidence.
this was a t-shirt.
Yes.
small boy by 9 years. He was twins. The informant is
She had been left in the custody of parents also. The younger son was 9 years also. He got information that the court didn't. अच्छा है
The witness is the doctor. Yes, sir.
who died actually
The 9-year-old child.
No, Kanu.
Devraj
Kanu.
Pula. This is
Son of informant.
petitioner is the just neighbor, my dear. And there is no eyewitness in the case. It's on the.
W 6, 12, and 8. They were playing outside the house. They heard the shouting of the deceit and they came inside and saw that the accuser is coming out with the bloodstained knife and this was found with the.
Actual commission of the.
Nobody has seen.
He was fleeing away from the.
He was just coming out of that room and they were
Holding
playing.
that
knife.
weapon of.
Yes.
Or the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 27/6/2011. As such, he has remained, and during trial, he was not on bail, and as such, he has remained in custody for more than 14 years. He further submits that there are no eyewitnesses to the occurrence and the case is based on circumstantial evidence. And since there is no chance of early hearing of the appeal in the near future, the bail application may be favorably considered. Learned counsel for the High Court of Orissa submitted that even though nobody has seen the actual commission of murder, but there are evidence that the petitioner was coming out of the house holding the weapon of offense. And the bail application was earlier rejected by this court on 4/1/2016. Considering the submission made by the learned counsel for the respective parties, the period of detention of the petitioner in judicial custody, the absence of any chance of early hearing, we are inclined to release the petitioner on bail, sterilization of fine. Main on perusal of the soft copy of the trial court record, we find that the complete final form has not been sent. Let the learned trial court be instructed to send the soft copy of the final form in toto. Stop. For such purpose, file be placed before the learned registered judicial, who shall make necessary communication to email to the concerned trial court for doing the needful. And after receipt of the complete final form, the same shall be scanned.
Yes.
Yeah.
Item 24.
May it please, Your Lordship. Item 24, my lord.
Yeah.
The appellant is in custody since 28 January 2011, my lord.
Yes.
28 January 2011, custody certificate earlier called for.
Custody and conducted.
Yes.
तो उस हिसाब कर ले
Around 14 years.
14 years.
14 years.
Including remission, 16 year, 9 months and 60.
Any no adverse
Submitted the conduct.
or the learned counsel for this petition single murder.
Single murder.
The learned counsel for the petitioner submitted that the petitioner is in judicial custody for more than 14 years. And there is no criminal antecedent against him. And there is no chance of early hearing of the appeal in the near future. Therefore, the bail application may be favorably considered. Learned counsel for the state has produced the custody certificate which shows that the petitioner is in judicial custody for more than 16 years, which includes the period of remission of
2 years.
2 years. She has also produced the written instruction received from DSP in charge of Kuchinda Police Station, Sambalpur, which shows that there is no criminal antecedent against the petitioner. The custody certificate as well as the written instruction obtained by the Land Council for the states are taken on record. Considering the submission made by the Land Council for the respective parties, period of detention of the petitioner in judicial custody, absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed.
Grateful, my lord. There is a one MC, my lord, for stay realization of fine.
Fine also allowed, yes.
Item
Class
25.
A.
Yes, that is allowed.
Grateful.
Item 25.
Item 20. So last petition, he
This
should
is
call
called
for
for
the
the
conduct
conduct
report.
report. Can I pay for day after tomorrow?
Acha. Land Council for the state submits that he is yet to receive instruction as per the order dated 10/9/2025, and the matter may be taken up day after tomorrow. It is this matter on 24th of September 2025.
Item 26.
This is registered last Friday, pursuing grant 3 months bail. Due to no, I was there, therefore. Last Friday, it was listed before the Honorable Court. Period taken into consideration, period of detention. This Honorable grants 3
Oh,
months.
you did not, but we
Yes.
passed the order.
Yes,
right?
there was no IA further pointed out by the.
The order are documented for the EMA. Sure. We granted interim bail for 3 months. Land Council for the petitioner, appellant has filed the interim application for bail in court. Let the same be registered. The Land Council for the petitioner submits that the petitioner is in judicial custody. Final from that. Anna Gono? Krishna Parikh. Since 15/8/2014. And there is no chance of early hearing of the appeal in the near future. What was your further submission?
The period of detention is more than 11 years.
That is there.
The local man, no chance.
And there is also no chance of absconding. Therefore, the bail application may be favorably considered. Land Council for the state opposed the prayer for bail. Yes, even eyewitness session in a found material. 396 case. He was found guilty. Huh? PW9.
Taking upon the period of detention, last appearance was.
Land Council for the state on the other hand placed the improved judgment.
Judgment, page 8.
And also the evidence of the doctor vacated PW17 who conducted post-mortem examination. In view of the available material on record, I will not intending to release the petitioner on bail merit, but taking into account his period of detention in judicial custody and absence of any chance of early hearing. And since the petitioner is a local man, we are inclined to release him on interim bail for a period of 3 months. While an interim bail shall not indulge in any criminal activity, out of 396, for example, he shall appear before the inspector in charge, Krishna Balgarfu Thana, Champua. He will appear before the IAC of Champua Police Station once in a week on every Sunday in between 10 to 4. Hello? Violation of any terms and conditions or rental cancellation of the data. Let the IV register for the
From the date of release.
obviously that would be. Yeah.
Item 27.
May I please allow? Space the prosecution director to obtain the custody certificate for the appellate number 3. In the meantime, filed a IA for bail for appellant number 1 and 2. No.
Custody certificate for it.
Appellant 1. Final form kind to call. लिखा ही नहीं जाए तो परिवार नोट नहीं हो फाइनल फॉर्म अच्छी बने लिख ले व्हाट इज द नेम अच्छा 11/7/2025 प्रॉपर्टीज के तो कौन है Appellant number 1 is the 10 years, 2 months, 12 days. Out of 9 वर्ष 9 मास. That fact. कितने जनों पे फाइल लीजिए? 1 and 2. Beginning I have filed for 3 only, but now 1 and 2. Now 1 and 2, na? This one is one. Is that the second is also joiners. It a petitioner selection. खाली petitioner elections. कहाँ पे फाइल कर देंगे? IA number, मतलब IA number 2572. कहाँ पे फाइल कर देंगे? Appellant number 1 and 2. केम जानी? First paragraph. Only and other stuff. First paragraph. Petitioners are the appellant number 1 and 2. If you like the humble petition of the appellant number so and so. आप ऊपर भी लिखता हैं ये बोलो तंको ना appellant number 1 and 2. Really? So, what is the case about? Yes, that the prosecution case is that on 7th of July 2015, 8th of July 2015, informant lodged an FIR before the PS that on the earlier date. Eyewitnesses are Your Mila? Who are the eyewitnesses to the eyewitnesses are 3, PW number 4, 5 and 6. Out of it, 5 and 6. Out of the doctor? Doctor is PW 10. PM doctor or PW 10? 10. Eyewitness has some evidence. PW John, PW 4 person. Out of 3 Miller, the PW 4 not supported the prosecution case. Not supported prosecution. 5 said that he has seen the incident 200 meters away in the mid 11 a.m. in the night, p.m. in the night. Marla, Tangia Fasa. The public road, Babulis wants to assaulted. Okay. And 6 has not supported the prosecution case. So 5 is the only witness who supported the prosecution. But he has seen the incident since 200 meters away. 10 has also stated about the injuries inside knowledge. Look, IA number one, so there is an application 2572 of 2025. There is an application for bail filed by appellant number appeal memo person.
1 and 2.
Appellant number 1 and 2, namely Khetra alias Khetravasi Deuri and Goppo alias Gopobandhu Deuri. The land counsel for the petitioner submitted that the appellant number 1 is in judicial custody for more than 10 years, and the appellant number 2 is in judicial custody for more than 9 years and 9 months. तो मतलब 3 या 9 वर्ष 3 ना 3 का 9 वर्ष 3 ना नहीं तो इटा अच्छे बाबुली नहीं ये जो
application is for only 2.
Listen, the further submits that though the prosecution examined 3 eyewitnesses to the occurrence, that is PW 4, 5, and 6, but PW 4 and 6 have not supported the prosecution case, and only PW 5 has stated about the assault on the deceased, but it stated that the occurrence in question took place at about 11 p.m. and he was at a distance of about 200 meters from the spot of occurrence. The Land Council submits that in view of the available material on record, the petitioners have good chances of success in the appeal, and balance of convenience is in their favor. Therefore, the bail application may be favorably considered. Stop. Land Council for the state has produced the custody certificate of both appellant number 1 and 2, which substantiate that the submission made by the petitioners regarding the custody period is correct. The Land Council for the state has also produced the report from the IIC Kishore Police Station dated 22/8/2025 to show that there are no criminal antecedents against the petitioners. Considering the submission made by the Land Council for the respective parties, nature of evidence available on record, period of detention in judicial custody, absence of any chance of early hearing, we are inclined to release the petitioners on bail, subject to condition that they shall not indulge in any criminal activity and shall not try to come in contact with the family members of the deceased, violation of any terms and condition shall entail cancellation of bail. Bail allowed. Let's see. Number 24. We are just coming to.
uh, 21 for appellant number IU number 24/21.
डिक्टेशन क्यों नहीं थी? हाँ? अच्छा आधे आउट आई रही है जो 20 एटा कहाँ पे फाइल कर जाने?
Milord, earlier it was filed 24/21.
That is for
Appellant number 3.
only appellant number 3.
Now,
We granted appellant number 1 and 2 bail.
in the new IO, that is IA number 2572/22.
So ठीक है, that is for appellant number 1 and 2.
1 and 2.
But you did not press for this 24 of.
Milord, I am pressing.
So that is
Years, only 9 years.
9 years.
Wait,
9
after
months,
this.
around 10 years.
Around
9 years.
9 months.
9 ये same version.
And
9 year, 9 months, 10 days.
no
rule are same. Rule same.
rules, no overtake, Milord. No overtake.
Same order कर दियो लेकिन तब तारा कस्टडी सर्टिफिकेट देई थिले?
हाँ सही तरह से
सही रच
ସେଇଟା ଅଛି ଯୋଉଟା ଦେଇଥିଲେ କହିଲେ ତାକୁ
फास्ट हाउस
Already.
9 year 9 month.
10 days.
bail allowed. Okay, next.
Item 28.
Appellant for more than 14 years and 6 months for the offense under 302
announcement.
10 years in custody.
Single murder.
Yes, sir.
This is with Bhagwan Devuri
Yes.
and you assaulted by means of a bamboo stick.
Yes.
Eyewitnesses are there.
3 and 9.
3 and 9.
3 and 9.
Yes, sir. Below 9.
Doctor is a 12.
161, he has not spoken anything. In
With the doctor,
12. Below 12. Below 12 has due to lack of proper treatment, which is died.
Bamboo stick.
or the land counsel for the petition, land counsel for the state. The land counsel for the petitioner submit that the petitioner is in judicial custody for more than 14 years. And there is no chance of early hearing of the appeal in the near future. Therefore, the bail application may be favorably considered. And counsel for the state, on the other hand, place the evidence of PW 3 and 9, who are the eyewitnesses to the offense, so also the evidence of the doctor of PW 12, conducted post-mortem examination over the dead body of the deceased. Considering the submission made by the land counsel for the respective parties, nature of evidence available, period of detention and judicial custody, absence of any chance of early hearing, we are inclined to release the petitioner on the allowed.
Item 29.
29 and paper day after tomorrow.
As briefed for by the land council for the state, put of this matter on 24th of September 2025.
Item 30.
Yeah.
पहले आए पूरे रिसील दे लो नोटिस या क्लास 7 नोटिस that to take instruction.
Received.
Suffering from skin disease.
I am skin disease.
ବର୍ତ୍ତମାନ ତ ଆପଣ ଠିକ ଠାକ ଅଛି।
There was only
that
some
dog reaction is,
reaction.
that is not a ground for
Skin disease.
then file an application otherwise, but on this ground you cannot, that problem is over. So you have become stable and normal without any medicine. Left file another application. You are filing this application for a particular purpose. IA number 2458 of 2025. This is an application for interim bail, which has been filed on the ground that the petitioner is suffering from skin diseases. As for the order dated 10/9/2025, and counsel for the state has produced written instruction received from the Superintendent District Jail, Denkana, which is accompanied by a report of the medical officer, Jail Hospital, Denkana, which shows that the petitioner suffered from skin drug reaction, and he was treated in the jail hospital and then referred to district headquarters hospital, Denkana, and subsequently to SCBMCH, Cuttack for treatment. And now his health condition is stable and normal without any medicine. The medical documents has also been annexed to the report. In view of such reports, we are not inclined to grant interim bail to the petitioner. Stands dismissed. Yes, next.
Item 31.
As the president of the insurance shortfall, regarding the conduct of the one and interim bail on 8/9/2021. Yes. Conduct achieve. Kete varsa rahechandi? More than 11 years.
11 years.
14. They are the land counsel for the petition, land counsel for the state. The land counsel for the petitioner submits that as per the order dated 23/4/2025, taking into account the period of detention of the petitioner in judicial custody for more than 11 years. For 11 years, it's more than for 11 years. The petitioner was granted interim bail for a period of 3 months. And after availing the same, he surrendered at right time and he has not misutilized his liberty. Land counsel for the state, as per the order dated 8/9/2025, has produced the report from IIC Chandipada Police Station, which shows that the conduct of the petitioner during interim bail period was good. Considering the submission made by the land counsel for the respective parties, period of detention of the petitioner in judicial custody, and since the petitioner has not misutilized his liberty in any manner while on interim bail, we are inclined to relieve the petitioner on bail.
Item 32.
Yes, Mr. Sahoo.
I am in sub-item 2.
You are also in item number 1?
What my lord, it has been brief has been transferred to my
now Mr. Chand is appearing. All right.
So, filed an interview application. And last time I was kind of direct the state to take instruction regarding the veracity of the
element of the wife,
element of the wife, and also the conduct and all.
Conduct kon apon jaitile ki bail?
Yeah, 4 times I have.
এটা হচ্ছে আসছি কার এটা?
ভগবান দলবেলা is my client.
এটা হলো ভগবান, আচ্ছা। Reported so-and-so. Suffering from chronic knee pain, joint pain, so-and-so. Presently undergoing treatment. Admitted and so-and-so. Custody issued by the so-and-so. It was a certain petition of the interim bail period. 2 weeks. No, 2 months so-and-so. Dithar jayichandu. No so-and-so fair election. Team digging the chair. IN number so-and-so. 1344 of 2025 is an application for interim bail filed by the petition. Mr. Manas Chandra and counsel appearing for the petitioner submits that the petitioner was granted interim bail twice by this court. First time by order dated 14/11/2022 for a period of 2 weeks, and again by order dated 21/5/2024 for a period of 2 months. And on each occasion, after availing the interim bail period, he has surrendered at right time and he has not misutilized the liberty in any manner. Moreover, the health condition of the wife is not good. The Land Counsel for the petitioner annexed some medical documents in support of the wife's ailment. The Land Counsel for the state was asked to obtain instruction on the interim application. Today, he has produced the written instruction received from IAC Saranpur Police Station dated 17/9/2025, which also reveals that the wife of the petitioner is suffering from chronic knee pain, joint pain, and back pain, and she is undergoing treatment. And the petitioner, and there was no criminal antecedent. And the medical documents produced by the petitioner are genuine, and during the interim bail period, no adverse report was, there was no adverse report against the petitioner. The report is taken on record considering the submission made by the Land Counsel for the respective parties. The arguments taken in the interim application, the medical documents annexed thereto, and since the petitioner has not misused the liberty granted to him earlier by this court, we are inclined to release him on interim bail for a period of 3 months.
Yes. Next item.
Just a minute. Since Mr. Chand has entered appearance in this case, let a main like this. After obtaining no objection from Mr. Prashant Kumar Sahu, the name of Mr. Prashant Kumar Sahu and his associates shall not be reflected in the cause list henceforth. It is 231. Yes, next.
And the next item, they allowed conduct during interim bail was.
Yeah.
My lord,
178.
178, my lord. My lord, I am now 65 years of age and suffering from.
Let us see this poster.
Not involved. कितने वर्ष अपन को?
My lord, now I am 65 years of old.
Period undergone.
My lord, 9 years, 6 months. 9 years, 6 months. I was arrested on 5/3/2016. 5/3/2016.
Or the Land Counsel for the petition, Land Counsel for the state. The Land Counsel for the petitioner submit that the petitioner is now aged about 65 years, and he has undergone judicial custody for 9 years and 6 months. And earlier, he was directed to be released on interim bail for a period of 3 months.
My lord, earlier to that, 2 months also. Twice I have.
Twice, once for 2 months and the other for 3 months. And after availing the same, on each occasion, he surrendered at right time, and he has never misutilized his liberty in any manner. As for the order passed by this court on 8/9/2025, the Land Counsel for the state has produced the report dated 17/9/2025 from IIC Saranpur Police Station, which indicates that during the interim bail period, there is nothing adverse was reported against the petitioner. Considering the submission made by the Land Counsel for the respective parties, age of the petitioner, period of detention in judicial custody, and since the petitioner has not flouted the terms and conditions of the interim bail order, we are inclined to release the petitioner on bail allowed.
Item 33.
Directed period of custody and control. One interim 3 months. Interim for 3 years, 3 months.
Only 1 year, 5 months in custody.
ବର୍ଷେ ଜମା ରହିଛନ୍ତି
During trial, he was on jail.
What are the some?
ଛୁଟି ପରେ ଛୁଟି ପରେ. The land council for the state has produced the custody. Sir, you are for the informant. We show that the petitioner is in custody for 1 year, 5 months. Same is taken on referral and counsel for the informant is present. Put up this matter after ensuing puja holidays. Yes, next.
In second case, more than both the matters.
Let it come with them. Yes, next.
Item 34.
CRM number 138.
Here I was granted interim bail. On the last occasion, my lords had called for the conduct file on interim bail, character antecedents, and custody hearing. I am in custody since 17/9/2018. I am a doctor. I have been convicted on the basis of circumstance alone.
When last time you were granted interim bail?
I was granted interim bail, my lords, initially on 23/9/2024. That was extended, my lords, from time to time. And the last order of extension was on 17/1/2020.
Six years, 6 months, Mr. No adverse report.
No adverse report. But
And jail conduct is also good.
way he has involved is very. The allegation is serious.
What is the allegation?
The wife of the deceased has.
Wife?
Wife of the deceased has. Appellant.
Wife of the deceased has.
Appellant.
Wife of the district judge.
What are you saying?
Wife of the district judge, na form.
No, appellant is involved in the case that.
I mean,
Allegation is serious, that's why.
that is on issue from one to keeping in motorcycle. Inform the motor since there's in suspecting the movement of the owner of that which from.
The eyewitness?
No.
Eyewitness.
He is a doctor.
My lords.
Which
He was posted at Chhatrapur, my lords, at the time of yours.
government doctor. Case based on circumstantial evidence.
Class in.
Or the land council for the petition, land council for the state. Land council for the state has produced the custody certificate to show that the petitioner is in judicial custody for 6 years and 6 months. He has also produced the report from the IIC DN2 police station to show that the behavior of the petitioner during the interim bail period was good.
What happened to Mamta Mai? Acquitted?
No, Mamta Mai was
not even charged.
So during the confinement, this behavior was good and nothing adverse was reported. The land council for the petitioner submit that the petitioner was granted interim bail By order dated
23/9/2024
23/9/2024 for a period of 8 weeks, which was extended from time to time. And after availing the interim bail period, he surrendered at right time. He is a government doctor who was posted at Chhatrapur at the relevant point of time. Considering the submission made by the Land Council for the respective parties, period of detention of the petitioner in judicial custody, since nothing adverse has been reported against the petitioner. And absence of any chance of early hearing, we are inclined to release the petitioner on the allowed.
Item 35. Item 35.
Thank you, sir. Lordship, the present appellant has been convicted of section 376 AB of the IPC for a period of 20 years. One bail application is already pending, Your Lordship. However, we have filed an interim bail application.
2493 of 25.
Yes, Your Lordship. Yes, Your Lordship.
For what purpose you are seeking some
In use of the father, Your Lordship.
father's ailment?
Yes, Your Lordship.
What is your instruction on this?
You have to obtain that.
Get it. Kodi ghara kodi.
In Gaurav Keujhar.
Keunjhar.
Day after tomorrow.
Day after tomorrow. IN number so also, this is an application for interim bail on the ground of ailment of the father of the petitioner, who is stated to be suffering from cardiovascular complications. Land Council for the state has received and medical documents have been annexed to the interim application project.
Item 36.
Filed an IA in criminal appeal 902 of 2024.
902, last on 8/9/2025, when the petitioner was released on interim bail for a period of 1 week. Surrender.
To attend the first anniversary of his wife's death.
You have surrendered?
Yes, my lord. I have annexed the surrender certificate to this.
Now any other application is pending?
Yes.
My lord, can I have grant to order dated 23/4/2025? 23/4/2025.
25.
My lord.
କେବେ ଆଉଥରେ କୁହନ୍ତୁ କେବେ
23/4/2025।
23/4/2025 କାହିଁ ସେମିତି ତ ଅର୍ଡର କିଛି ନାହିଁ 8/9/23/4/2025 ର କିଛି ଅର୍ଡର ଅଛି କି ଦେଖିବ ଏଇ କ୍ରିମିନାଲ ଆପିଲଟାରେ 902 ରେ ଫାଇଲ ହେଇଛି
My lord. Nothing ମଧ୍ୟ ଅଛି common order passed in CRL 924
hearing କରାଯାଉ
924 ରେ sir
924 ରେ
ହଁ paperକୁ ready ହେଇକି final hearing ପାଇଁ ଏଟା ଥିଲା in the matter was also in the hearing list.
Okay. All right, let's this matter after vacation, but after puja.
My only prayer is this.
Yeah.
So far as the appellant here is concerned in 902, he is aged 80 years.
Okay.
And in view of that NALSA recommendation.
Yes.
All right. After puja holiday. Yes, next.
Let him obtain the antecedents, behavior, etc.
All right. The Land Council for the state shall obtain the instruction about the criminal antecedent of the petitioner, who is stated to be 8 years. So also his conduct inside the jail. Without
and also conduct while on interim.
Item number 902 of 2024 likhi. IN number dita kon file korchundi bail pai who bill ta press korchundi Mr. Panda, you have filed 2306 which is pending. You have filed another application 2599 of 2025. The latest
I am pressing 2599.
Acha, not press kar diyantu. IN number 2306 of 2024 এটা নট ফেস করে দিবেন এইটারে লিখি দেবে হলো এজ লিখি দেবে তারপরে period of run he was granted interim bail since he was granted interim bail by the order dated so on so he shall also obtain instruction regarding the conduct filed on interim bail. Yes, next.
May I please, Your Lordship? Item
Item
37.
37 years.
Yes, Lordship. Lordship, the petition, the appellants, the present case have been languishing inside custody since 6/2/2019, Your Lordship. On the last occasion, Lordship directed for verification of the custody certificate, Your Lordship.
He had conduct.
Contact on finally
Criminal antecedent or
day after tomorrow. The land council for the state seeks for an adjournment till day after tomorrow to obtain instruction as per the order dated 10/9/2025. Put up this matter on 24th of September 25. और दिन आसचु हां 24 तारीख
Item 30.
Yes, Mr. Swine.
38 also we are not received. That I said
Not
day after
received.
tomorrow.
Same day after tomorrow. 24/9/2025. Yes.
Item 39.
I have kindly taken it after this. I have filed counter in this matter. Second time which has come, I have sent for
Just
the
a minute. You are appearing for whom?
bank. I opposite part now 4.
So
I am appearing for opposite part number 10 matter.
just a minute. Mr. Guru Datta Koro, Land Council for the opposite party number 4 is present and he seeks some time to file counter affidavit. Stop. You are appearing for?
हमारे नाम शाश्वत कुमार रेड्डी on behalf of Mr. Amitabh.
नहीं कितने number opposite party?
39. I am appealing for the petitioner.
Oh,
I am appealing
petition.
for opposite part number 10 matter.
Just a minute. The Land Council for the petitioner is present and you are for?
OP number 10 matter.
Good name, Land Council?
DN Mishra. RBI Bank.
Mr. DN
Mishra.
DN Mishra, Land Council for the opposite party number 10.
There are 4 opposite parties.
4 opposite parties.
Well, I know 10 matter. Reserve Bank of India.
Reserve Bank is not a party.
Reserve Bank. This is Ombudsman, Office of the RBI, Banking, so and so.
What is it? RBI is not a party.
But all the notice had gone well.
Huh?
Notice has gone well.
देखिले नंबर टाटी देखिले
10 men.
No, there is only 4.
এটা পিটিশনৰ না দেখুন মা সমলেই রাইস মিল গঞ্জাম এই কেস রে
No matter. That is
14425 read petition number.
Sorry.
अच्छा put up this matter केबे रखिवा कोन
After vacation.
13th रे रखिवा एपटे एपटे कैलेंडर now दरकार समय
नहीं.
Here,
30.
please this matter in the week commencing from 13th October 2025.
Oblige.
Counter affidavit, if any, be filed in the meantime, giving copy to the Land Council for the petitioner in advance. Sir? Yes.
Item 40.
Let's say I am the opposite party. We appeared last year for me time to confirm.
Counter affidavit not filed. What is your good name? Huh? Eke Barik. Yes, ma'am.
I'm appealing for the petitioner.
Acha. Good name, Land.
Arjuna.
Arjuna, Land Council for the petitioner is present. Mr. Eke Barik, Land Council, opposite party submits that he may be given some more time to file the counter affidavit. Please this matter. Say 13 तारीख रखी दो शू. Please this matter in the week commencing from 13/10/2025. Counter affidavit, if any, be filed in the meantime, serving copy on the Land Council for the petition. Yes.
What password?
Which password? Wait, the launch for another single bench list.